A constitutional democracy is built on a massive contradiction. It requires the consent of the governed to exist, but its primary function is to protect the governed from their own consensus. When the legal system talks about public opinion, it isn't talking about raw majority rule, or whatever idea manages to capture 51% of a vote on any given Tuesday. Look at these legal notes breaking down political scientist A.L. Lowell's theory. True public opinion has to be an aggregate thought geared toward the common good. If an aggregate viewpoint is highly detrimental to a specific minority class, it fails the rational test. It instantly ceases to be a valid public opinion, regardless of how many people hold it. The relationship between law and public sentiment operates as a complex bidirectional feedback loop. It's a system constrained by strict constitutional and international firewalls. Understanding how this architecture works is the only way to comprehend how a modern republic keeps the will of the people from devolving into the tyranny of the majority. To map this system, we start with the 19th century baseline established by British jurist A.V. Dicey in Law and Public Opinion in England. Dicey proposed a straightforward model. In an advanced civilization, the legislature inevitably trails behind prevailing currents of public sentiment. In this framework, the rule of law relies heavily on formal procedural equality and the supremacy of rules over arbitrary power. But this model carries a fatal flaw. It assumes a culturally and demographically homogeneous society. When applied to complex populations, Dicey's reliance on formal procedural equality acts as a mask. It hides deep structural and socioeconomic disparities behind a veneer of neutrality. A linear, majoritarian pipeline is entirely insufficient to map the realities of a hyper-diverse constitutional democracy. In a pluralistic state like India, public opinion never manifests as a single national monolith. It passes through a series of manifestation filters. Before reaching the legislature, aggregate sentiment coalesces around deep-rooted regional, linguistic, and religious identities. We saw this clearly in the mid-20th century, when mass mobilizations like the Dravida movement forced the government to reorganize state boundaries along linguistic lines. This regionalism creates tension. Locally, it fosters targeted development and community brotherhood. But excessive regional attachment creates supra-state factions that continuously challenge the central administration. Because aggregate opinion is splintered by identity long before it hits a ballot box, the legal system cannot passively receive it. The architecture has to actively manage and balance these competing demographic demands. This reveals that the relationship between law and society operates as a continuous, dynamic feedback loop. The first vector runs from the bottom up. Mass mobilization and direct public pressure frequently force legislative decay or immediate repeal. Look at the scale of this mobilization from 2021. After widespread, sustained protests across the country, the Indian government fully repealed 3 major agricultural laws. The public forced the law to bend. But the second vector runs top-down. The state routinely uses progressive legislation as an instrument of social engineering to alter private behavior. The Hindu Marriage Act of 1955 imposed monogamy and introduced divorce into personal law. It took decades, but this legal statute successfully molded societal behavior until it became a widely accepted social norm. The law acts as both a mirror, reflecting the immediate demands of the public, and a hammer, forging the shape of future societal morality. This creates a critical stress test. What happens when an overwhelming social consensus demands a law that strips rights from a minority? The system relies on a rigid firewall. Indian jurisprudence distinguishes between social morality, the prevailing prejudice, and constitutional morality, protecting fundamental equality. The judiciary is structurally designed to bypass and sometimes directly oppose massive and angry societal majorities in order to uphold fundamental justice. We see this intense friction in action. In the Sabarmala case, the Supreme Court struck down traditional practices, restricting women's temple entry, directly overriding massive, organized social resistance. Similarly, when striking down Section 377 to decriminalize homosexuality, the court bypassed social morality entirely to expand rights. You can see activists here explicitly citing the constitutional morality argument in the public square. Contrast this with the United States system. Cases from Roe v. Wade to Dobbs show the ultimate judicial arbiter acting completely insulated from, and often in direct opposition to, intense public furor. Constitutional morality acts as the system's emergency brake. It ensures justice is determined by enduring fundamental rights, not the volatile passions of the daily majority. There is one final complication to this model. The system is entirely permeable to the supranational vector of global public opinion and international law. Under Article 253 of the Indian Constitution, Parliament is empowered to enact legislation to implement international treaties, creating a top-down legal obligation. The clearest example of this global consensus is international refugee law, specifically the 1951 Convention's rule of non-refoulement, which prohibits returning individuals to face persecution. India presents a profound anomaly here. It is not a formal signatory to the 1951 Convention. Yet, customary international norms exert such pressure that India has historically maintained a generous domestic stance toward refugees. Look at these specific handwritten notes on demographic data. In 2017, a clear 60% majority of the domestic public wanted to close the borders, but the borders remained open. Domestic law is rarely isolated. It frequently bends to accommodate the overarching standards of global customary law, even when local consensus disagrees. When you map the entire architecture, you see how far we have moved from a simple majority vote. Public opinion in a functional republic is never merely the loudest demands of a voting bloc. It is an idea that must survive a rigorous gauntlet. It has to satisfy the rational criteria of the common good, survive the rigid filter of constitutional morality, and balance against global customary norms. This complex legal machinery is not an accident. It was intentionally designed by framers like Dr. B.R. Ambedkar to navigate a society of extreme contradictions. The system governs consensus to promote the general welfare while permanently locking the fundamental rights of the minority safely out of the majority's reach.